This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game? Well, with the Name Your Price tool from Progressive, you can find options that fit your budget and potentially lower your bills. Try it at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
Hey, I'm running out to drop off a stack of letters and packages. Need anything shipped while I'm gone?
Save the gas. Stamps.com lets you print postage and schedule pickups right from your desk. Sync your contacts into the address book, get detailed accounting insights, and get notified the moment your certified mail is delivered.
All from my desk?
All from your desk.
Join the 4 million businesses using Stamps.com right now with code PODCAST and get your free welcome gift. Stamps.com, code PODCAST. Taxes and fees apply.
Well, hello. This is Mark from the Swamp School. I want to welcome you to another edition of our Wetland Wednesday. We're either posting this late or early. I'm not sure where this fits on the calendar, but we are doing this for our September edition. And specifically today, we're going to be talking about the Pasqua Yaqui tribe's case against the United States EPA and the Army Corps and so forth regarding the Naval Waters Protection Rule. Now, as this is a legal case, I want to clarify that this podcast is for entertainment purposes only. I am not an attorney, and I do not represent any, I'm not qualified to offer legal opinion in this matter. However, this is a entertaining opinion, essentially, of the case. So take that for what it's worth. Now, as far as the case goes, the Pasqua Yaqui tribe basically filed a case against the two final rules related to the Naval Waters Protection Rule and the 2019 Army Corps of Engineers definition of the waters of the United States. The 2019 version was replaced by the Naval Waters Protection Rule, so there was two cases considered. The result of this case, just to kind of jump to the end here, is that the judge essentially heard a motion from the EPA that the EPA basically was not going to defend the case. Essentially, they were going to remand the case back to and repeal it, essentially, back to the previous edition, I guess, if you will. And so the EPA was not intending to defend anything. So the idea was that the case then was not really a summary judgment. It wasn't decided to be summary judgment. It was simply the judge approving the EPA's decision that they would remand the rule. In addition, the EPA had specifically asked it to basically remand it without vector, which essentially is that while the cases, the Naval Water Protection Rule would have been repealed, essentially, the way to think of it, it would stay in place until such time as the Biden administration came up with a new rule. However, the judge ruled that it would be with vacor, which means essentially that the rule is vacated effective immediately. So that would roll it back to essentially the 2019 rule, because that's the next one in line, presumably. And actually, that needs to be clarified. But that's essentially where we're at. So now, a couple things that come out of this and kind of get into why is to what extent does this affect us? Well, if you are in the District of Arizona, essentially the state of Arizona, this directly affects you because that is it was decided by a district court judge, a federal district court judge for the state of Arizona, or for the District of Arizona, I should say, within the state. Now, the District of Arizona is also in the Ninth Circuit, so if an appeal was to be made, it would go to the Ninth Circuit. And historically, the Ninth Circuit would probably have just upheld the federal district court's decision, so this would be then off to the Supreme Court. So that's essentially where we're at right now. So I guess the Reader's Digest version of this is that effective immediately, the Naval Water Protection Rule is no longer effective or in use for the District of Arizona. Now, there are some interesting twists to this. First off, that there are some other plaintiffs, there's other plaintiffs and also other defendants. The plaintiffs include a collection of Native American communities, mostly from Wisconsin, which I thought was kind of weird. But the Pasqua Yaqui tribe is actually in Arizona, but they're also in Fond du Lac, up in the Lake Superior, and we have a tribe from Wisconsin, and we've got some more Chippewa tribal communities there. So there's actually kind of a collection of Native American communities as the plaintiffs, which I find kind of interesting. Again, the legal side of this perplexes me because The Native American communities have their own rules and regulations, and essentially through the Bureau of Indian Affairs, they even have their own EPA. And the idea is this was not filed within their courts; it was filed within the United States District Court. So there is a question of, I guess, if you'd say, appropriateness of how this would be interpreted, even at the district level or nationally. I mean, anybody can sue anybody for any reason, but the issue is that it's almost like you're having another country, suing, essentially the EPA. It'd be literally as if Canada had brought this case before the courts. So, and maybe it's my naivete, basically my lack of knowledge of the law as to how that would work. But that's an interesting issue. Second is that what happened is the EPA did not actually defend itself. Essentially, what it did was said, okay, fine. There was actually initially a motion for summary judgment, and essentially the EPA said, okay, well, in lieu of that, we're not going to get a judgment. We're just simply going to give up. An analogy would be essentially, if you get a speeding ticket, rather than fight it, you just send in the check. And that's essentially what the EPA did. And they essentially made a motion for what they call voluntary remand and their request was basically a voluntary remand of the Navajo Water Protection Rule without vector, essentially. The plaintiffs did not oppose the remand, but they argue that it should also include basically the vector, which essentially would make it go away immediately. So the Native American community wanted it to go away immediately, and that's essentially what happened. Now, the other group that got involved on the defendant's side got very interesting. Chantel and Michael Sackett from the Sackett case of 2012 filed a cross motion for summary judgment. And also there was defendant interveners, including a lot of Arizona-based organizations: Arizona Rock Products, National Stone and Stand of Arizona, Cattle Associations of Arizona, and Home Builders Associations of Arizona. All these Arizonians basically filing as interveners, essentially, on the defendant's behalf. They actually, what I'll call the industrial groups, actually were okay with the remand. The Sacketts were not. The Sacketts actually were looking for both to fight, basically remanding the rule as well as the vector. So it's kind of an interesting group that was on the defendant's side. So they voluntarily defended it. Now the Sacketts, I'm presuming, I can't 100% validate this, but the Sacketts were very instrumental in the case against the EPA back in 2012, and the Pacific Legal Foundation supported them on that. I suspect they were involved in this as well. I've been checking their website and haven't seen much about this case on there, but maybe that will show up. But they're basically very interested in this case as well. But the other side of the jurisdiction on this is what is the implications of this on a national scale? There's been a lot of discussion about, well, okay, a federal judge made this ruling, and actually it's a ruling sort of, it's basically, again, I use that speeding ticket analogy. The EPA didn't defend anything, so the judge really didn't make any decision per se, other than just to agree with the EPA that they should pay the fine and go home, essentially, or just walk away. So the question is whether or not this has a national implication outside of the District of Arizona. Well, there's two concerns on that. One is that in order for that to happen, the Biden administration's Justice Department would have to actually make that statement. That's where we're expecting to hear this. Yes, this has national implications. So the Justice Department would have to make the determination. The Biden administration could do it independent of them, but usually they would do that with support of their own Justice Department. If not, that gets more complicated. So we do have that weighing on us. So it's fair to ask, is the Navajo Water Protection Rule in effect nationally? It seems like it's in effect nationally, except for Arizona. But again, we don't know. So I'm leaving that one up in the air, and that's a big question mark, because it's a completely different way of looking at what are the United States definitions. So this is a big deal. The second issue relates to the actual, I guess, why they were going for summary judgment, is that there has to be some sort of aggrieved party on this. And this is where it gets a little bit strange, because the judge's opinion and why she granted the EPA's request to basically give up was based on the fact that there was a greater good, I guess, concern about environmental, issues that come up. Well, the greater good is not really, there's no evidence in the case on that. Now, I'm not disputing that wetlands are important. Obviously, we make our living making sure people understand about wetlands, but there was no evidence produced in front of the judge. So the judge was kind of acting more like a Supreme Court justice than really a judge, weighing on the merits of the case. And it just seemed odd. Now, again, I'm going to confess my ignorance on how this process works in that much detail, but it seemed a bit odd because there was a lot of discussion in there about how the EPA should be following, or the Trump administration should have been following the connectivity report and a whole bunch of other stuff that went back to the 2015 rules for the Obama era rules, which, if you'll recall, were also held up in courts largely because there was a writ of habeas corpus on those cases because the states were aggrieved because it was an infringement on states' rights, and that was essentially why the 2015 rule was overturned. To go back to the 2015 rule would open that box up again. That is why the 2019 rule, which was also part of this decision, however, it has been put on hold in terms of the decision. The judge basically had ordered that within 30 days, so this would be the end of the end of September, that the plaintiffs and or defendants, such that they seem to be on the same team, but basically the plaintiffs and defendants should basically respond with a proposal or proposals for further proceedings concerning the plaintiff's challenge to the 2019 repeal rule, which was in count 5 of their complaint. So the issue there is that the 2019 rule is also on the chopping block, and if you recall, the 2019 rule is simply a recodification of the 1986 rule, plus all of the 2015 guidance and documents and essentially decisions that came out. They kind of enjoined them all in one big package. Unfortunately, there was no real procedural, what is the waters of the United States that came out of the 2019 rule, because a few months later, the Naval Water Protection Rule came out within weeks later, actually, came out pretty quickly. So the 2019 rule seems to be a backstop against the 2015 rule. And I think that's essentially what the Trump administration had set it for that purpose. So the upshot of it is that right now, we have a lot of ambiguity. We don't really know the extent of this rule's reach as far as does this have a national extent or not in terms of this decision. And if it does, we need to be told, essentially. And so somebody has to make a decision as to whether that's happening. You cannot imply it based upon the single judge's rule on this. She was acting kind of like a justice, though. Anyway, but that's another issue. At any rate, the other side of this is the Sackett's brought up a point which I think is kind of interesting, which was that the Sackett's were citing out-of-circuit authority finding remand with Vacor inappropriate in the absence of merits of adjudication, which was their issue. However, the judge rejected that because the parties had not identified any Ninth Circuit case holdings. And so the Sackett's evidence was thrown out essentially because of their arguments were outside of the Ninth Circuit, which brings into another possibility that could this be simply related to only those projects within the Ninth Circuit, which would be another way to at least identify it. So there's, again, the jurisdiction and I guess the reach of this is very much up in the air. You can try to ask the Corps, in all fairness to the Corps and the EPA, any of the folks who are working in the regulatory side of this, I doubt they'll have an answer because this has to come from really the Biden administration's White House. It has to come from Justice, and they have to spell it out. Maybe we'll see that shortly. Maybe they've already done it and I've just missed it. But it is something that is supposed to have happened or happened very quickly because the EPA was not asking for the immediate vacating of the Naval Water Protection Rule. They were really looking for this to basically be, remanded, which is a slap on the wrist and saying, okay, we're going to remand this. And as soon as you, come up with something that can replace it, it will replace it. And that's what they were looking for, not an immediate vacating it. So I suspect that they're not going to want to see this have an applicability across the nation either, because it will result in total chaos at this point, because then essentially we don't really have a rule, or it's even questionable, is the 2019 rule the appropriate one to go back? That's not crystal clear that, okay, well, we had one rule that defines something. Again, one of the biggest points of confusion on all of these definitions is that we're simply defining what is and what is not under federal jurisdiction under the Clean Water Act. If it's under federal jurisdiction, there's this presumption that somehow, because it's regulated, it's going to be protected. There's not one syllable in any of this that has anything to do with protecting it in any of these regulations that have come out. It just simply defines what is to be regulated and not. Protecting is not something that this definition delves into. Now, there's certainly the idea is that if you think that, well, okay, the Army Corps of Engineers has jurisdiction over it, that must mean protected. If you recall, the Army Corps of Engineers' mission, and is clearly stated in the Clean Water Act, is to develop a permitting program for the discharge and dredge and fill material into waters of the United States. That hardly seems like a protection program. It sounds like they're basically coming up with a system for filling in wetlands, which is effectively what they've done. And I'm not trying to pick on the Corps, but that's what the law says. That's what the regulation and the actual Clean Water Act says. So to look at them and say, okay, that's a protection group, it's not really their mission. Their mission is to develop a permit program, and it's under commerce issues, under the Commerce Clause. So the protection side of it comes really more under Section 401, which is pretty much handled off to the state, which is the water quality issues. And those are really up to the states. And I think that's what the Naval Water Protection Rule was kind of underscoring. Maybe it offended a lot of people on this front, but basically was underscoring that this is the state's issue, not really a federal issue. And that was the goal of it. So to that end, the new Biden administration's rule that they may come up with is simply going to be yet another definition of what is a waters of the United States. So fine, okay, they have jurisdiction over it, but does that mean it's protected? And that's really still up in the air on that. So just because it's regulated, and again, historically, regulated things are not usually the things that get protected. So it's a little bit weird about that. I mean, yes, you may get a denial of a permit because you didn't follow this rule or that rule, but at the bottom line is that the protection side of it is not part of this. That's kind of the next step. And again, that usually ties in with other permitting actions such as the 401 water quality certification, things like that. So there are other stopgaps there. But anyway, it's sorry this is a bit longer than we normally go. It's a fairly complicated interpretation of this. I recommend that you take a look at it. We posted the actual decision such that it is on the site. It's a mere 11 pages long. It's not too bad. But it is interesting. But we are a bit concerned about what this is going to mean as our client base, or consultants that deal with this and the regulators are needing clarification as to what is regulated, what is not. And right now, that's very much up in the air nationally until we get told, okay, this only is applicable to Arizona, or is it applicable to the entire United States? And maybe in the next few days, we'll have an answer to that. But we'll see. So anyway, that wraps up this one. Lots of stuff to talk about. Definitely post your comments on this. Would love to, any feedback on it. If you disagree with me on any of this stuff or agree with me, please post a note on the blog site. That would be real helpful, because I'd like to get a conversation going on this. And if anybody has some insight or would like to be a guest blogger or podcaster, I would be more than welcome to entertain any of your comments on here. So with that, I hope you enjoy. Hope this was enjoyable for entertainment purposes only, and I hope it was fun. And if we can be of any entertaining help, please give us a shout. Thanks, and have a great week, and have a great month.